Antonin Miranda Continuing Legal Education Seminar, which is free of charge. Can't beat that with a stick. Tonight we're partnering with the California Association of Marriage Family Therapists. How many therapists do we have here this evening? We've got a nice turnout. Thank you, folks. Thank you. We have an amazing amount of information to get out tonight and not enough time. So stand by to stand by. There are cards at the end of each table. Those cards are to write questions. Please feel free to write any questions that you want to have asked of our presenters tonight. And there's also going to be 2 question and answer opportunities, and we'll let you know when those times come. Once you filled out a question, raise it up, and someone will come by to pick that up from you. Tonight, we have, the presentation is When Child Welfare Services is Involved. Dun, dun, dun. Tonight I'll be presenting all things CWS. How does Child Welfare Services determine an emergency? The factors Child Welfare Services considers when determining findings, parents' rights, procedural information, how Family Court Services works and its different levels of involvement, and the role that therapists play, treatment plans, reunification, and probably most importantly to the family law attorney, how to keep your case from sliding into juvie court. Our first speaker tonight is NaTasha Bailey. She's a marriage family therapist. Here in California, she earned her Bachelor's of Science in Human Services in 2004, went on to pursue a Master's of Science in Marriage, Family, and Child Therapy from the University of Phoenix in 2011. Since 2015, NaTasha has operated her part-time private practice in Chula Vista. NaTasha has also worked as a protective services worker with the County of San Diego Child Welfare Services for 4 years, helping families involved with the County of San Diego Health and Human Services Agency Juvenile Dependency Court, providing reunification services for families. The bulk of her experience has been focused on providing psychotherapy to adults, couples, adolescents, and families in San Diego, and helping parents navigate the child welfare system, understanding their rights, case plan, and reunification services. NaTasha is going to address now the focus on the CWS process and the social worker role.
Good evening, everybody. First, just a disclaimer, I'm currently not an employee of County of San Diego. I resigned from protective service worker several years ago. So I'll be speaking to my experience as a protective service worker, social worker at that time, and going over some protocols that we have to follow at that time. I do still have friends that work in the system, so of course I, touch base with them just to make sure all my information is relevant. But first, before I get started, is anybody aware of something really big that's going to happen this Sunday? Sunday coming up? I heard it. Super Bowl. Super Bowl Sunday, yes. And believe it or not, historically, Super Bowl Sunday is one of the events that happen that then the following day, Child Welfare Services receives the most child abuse phone calls after Super Bowl Sunday. Yeah. So a lot of social workers during my day would like to take that day off, that Monday off, because those they will be coming in through the hotline, child abuse hotline. So just a fact there. So first, I'm just going to talk about some of the learning objectives. I'm going to talk about the functioning of a social worker. I may reference social worker, any worker that's working with juvenile dependency is referenced as protective service worker. So you may hear those both, just really one of the same. I'm going to talk about their processes, the role of a term therapist, and legal aspects. And I'm going to be talking role of a term therapist because they are mandated therapists that work directly once the case goes to juvenile dependency. I also will touch on the role of a therapist that is not a term provider and it's not juvenile dependency, and currently how therapists work with their clients if they become involved with CWS and how to advise them so they don't have to be mandated to a term therapist. And then lastly, legal aspects. So first, in your handouts, if you want to turn to the very first handout, the Child Welfare System Appendix, I'm kind of going to flow from there and start at the beginning. So after Super Bowl Sunday and the phone call comes in on Monday to the child abuse hotline, this is what happened. Because the CWS system is very complex, this handout is just a brief overview of the purpose of how the system works. So if a suspected child abuse or neglect is called to the hotline, what happens is it goes to the child abuse hotline. There are 3 units that they have. It's the ER unit, which is the Emergency Response Unit, Court Intervention Unit, Continuing Unit, and Adoptions, and there's also a Voluntary Unit. But what happens first is the phone call comes in and then it's screened in or it's screened out. And what happens is if it's evaluated out or screened out, it's not enough information for the hotline worker to assign it to a social worker. Maybe they don't have an address, maybe they don't have the child's name or school or date of birth or parents' information, so they will evaluate it out. However, they will look into the system to see if there's any historic information or active information, try to match names, to see if there's active cases. Also, when it's screened in, they're doing a risk assessment. There's an algorithm that they use called Structured Decision-Making Tool, and it's a solution approach based. So what happens is they'll enter the information into the system for consistency. Also, consulting with the leads, they determine at that time if it is a safety concern that exists. Once they determine a safety concern exists, at that point, the worker has 30 days to investigate and close the case or transfer the case. And when they transfer the case, it's usually transferring to a court intervention, which is then moving to juvenile dependency, perhaps, depending on the outcomes, or voluntary social worker, which is non-court involved and case plan. So at that point, they investigate, they go out and interview victim parents, interviews. A lot of social workers, protective service workers, will prefer to interview the victim, the child, at the school. I know that brings up a lot of concern because you want the parents' consent, but they do have the right to interview the child at school. One caveat, however, is the social worker does need to ask the victim if they want a school staff person present while they're interviewing with them. They have to ask them, and they can choose who they want to be in the interview room with them. They have to have a confidential space to do this. At that point, all collaterals or interviews are done. They should call back the mandated reporter to get any information at that point. And then they determine through a safety assessment, consultations with their supervisor, how the case should move forward. Sometimes if there's safety concerns and it's just a moderate concern, then the case can be closed at that time. Sometimes it may still need to go to the next level. And you guys have the handout, so I'll just switch to the next slide. So at that point, going to the next level means unsubstantiated, which is also known as unfounded sometimes. And so it's just not enough evidence significant to move the case along. Maybe the family just needs, some psychoeducation about spanking, or some referrals to the community, and it's no risk found and the case is closed. However, if it is substantiated at that point, that just means immediate safety. If the child is in imminent danger, if the social worker, protective service worker leaves the home, leaves the school, and the child goes back to the care of their caregiver, they were at immediate risk for harm. So at that point, it is substantiated. And then inconclusive, again, just not enough information to move forward at that point. If the case is substantiated, at that point, it is moving to the court intervention unit. They hold the case up to 2 weeks. It just depends. That unit writes the court report to the court to remove the child at that point. At sometimes it can go to the court intervention unit, and then there's other protective factors that are founded, and then maybe the case will be not moved to court. So you can also have what they call NEFRMs, non-related family members, that a child can stay with in spite of, as long as they're clear, the child can stay with a family member to protect them, and it can, and the case can be closed. Worst case scenario, of course, the child is placed out of the home in foster care, and services are provided to the families. Usually at that point, my role when I work for Child Welfare Services, I work what we call continuing or reunification unit. That social worker's role is to provide case management to the family, to the victim. They have to visit the child at least once a month, and it can't always be like in the foster home. You have to visit the child after school, in the home. You have to, make sure you're not interviewing the child or checking on the child in the same environment. So once it's in reunification services, they have, at this point, received a case plan, and I'll talk more about that on the second part of my presentation. If the case is closed and sent to voluntary, then it's family maintenance and there's no court involved. This is kind of how the role of the social worker comes in. As I mentioned, you have the emergency response, court intervention, continuing, adoption, and also there's voluntary. I left out there. They investigate, determine the degree of danger, and then conduct a written report and or close the case. And that's kind of how the whole system works there. What happens at that point if court-ordered services are mandated and there is a CWS plan? These are some of the services that the social worker will offer in a case plan. Not all, but some will be offered, and this can be offered if the case goes to through juvenile dependency and or if the case is voluntary and the family accepts a voluntary case. At this point, I will turn it over.
Thanks, NaTasha. The next speaker, we actually had two speakers. One of them could not attend tonight, Paul Leahy. He's had a family emergency that he had to attend to. Our thoughts and prayers go out to Paul. Donnie Cox, though, is fully prepared to address all of the information that they were going to do together. Donnie Cox is an attorney. He's been practicing law since 1980. Hello, is this thing on? Can you guys hear me without it?
Yeah.
All right, excellent. Specializes in civil rights, personal injury, and particularly cases involving the unlawful removal and detention of children from their parents by law enforcement and child protective services. He's been an attorney of record, co-counsel, or consultant on almost every published and seminal case involving family civil rights law since 1999. Has litigated more than 40 civil rights matters to trial or settlement, resulting in more than $30 million, including annuities for minors, in recovery for clients, and has worked successfully to change policies and practices related to removal and detention of children, physical examination of children, and interviews of children by law enforcement and child protective services in more than a dozen counties in San Diego. Donnie's going to be talking about parental rights and procedural information related to child welfare services involvement.
Thank you very much. How many people were at the seminar that we gave for Antonio Miranda about 6 months ago or so? Not too many. Good. So there's a lot of information to impart, and I'm going to try to do this as quickly as possible. The case that you see up on the board up there is Wallace versus Spencer. That was the very first case that set out the rights of parents and children when children could be removed from their parents. This case talks about the issue of two major issues. The first one is, let me see if we can make this work. And this is from the case. And when can the state remove a child from parents' custody? This is from Wallace. Officials may remove a child from the custody of their parents without prior judicial authorization only if the information they possess at the time of the seizure is such that it provides reasonable cause to believe the child is in imminent danger of serious bodily injury in the time that it would take to get a warrant. That has been repeated over and over again in dozens of other cases, both published and unpublished, in the Ninth Circuit and in federal district courts throughout the Ninth Circuit area. What it really means is that unless the county can show that that child is going to be physically injured in the time that it is going to take them to get a warrant, they may not remove that child. That includes they may not remove the child if they believe that there's imminent danger of serious psychological harm. And that's because in the time that it would take them to get a warrant, which in most cases is less than 24 hours, there's no such thing as imminent danger of psychological harm in that period of time. Now, there's a case called Rogers versus County of San Joaquin in which the children we refer to it as the dirty house case. And those kids were living in a house that was just pretty nasty, pretty dirty. But the court said that there was no danger that they were going to be physically injured in the time that that would have taken to get a warrant before they were removed, and they found that removal was unconstitutional. So one of the other things that Wallace says that is strictly circumscribed by the agency that justified the removal. So, for instance, in the Wallace case, I'll give you a quick primer on Wallace. Bill and Becky Wallace's sister, Becky's sister, was in a mental institution in Northern California going through repressed memory therapy. I don't know, we have some therapists here. You know how many people remember that garbage back from the 1970s and 1980s. It dealt with satanic ritual abuse. Same thing in the Martin Preschool case. Anybody that's lived in San Diego for a while will remember the case of Jim Wade and Dela Kiki. Those cases also involve satanic ritual abuse, and which has been completely debunked. Becky's sister told her therapist, who was in Northern California, that her sister and brother-in-law were Satanists, and that they were going to sacrifice their youngest son to the devil on the fall equinox of 1991. Without doing any investigation whatsoever, the brain surgeons from Child Protective Services in the city of Escondido came out and snatched these kids out of the house in the middle of the night. They actually followed Becky home from work. She worked at a grocery store, pulled her off the freeway, made her take them to the house, and where they removed the kids, and then they put them through the most horrific physical examinations imaginable the next day. Fortunately, Judge Reinhardt from the Ninth Circuit was the judge on that case, bless his soul. And it took 9 years to get that case through the courts. Rather, this happened in 1991, and if you saw the site on this, the final decision came down in 2000. So these cases take a while. But this is really the seminal case in the area. There have been 3 or 4 other cases that have come down since then. May versus County of San Bernardino, that also deals with exigency and what kind of information they can garner before they can remove a child. So, let's see. So, this is a case involving the rights of one parent and who. So if you guys, especially the family law lawyers out here, have a case where the social worker is saying you need to go out and either get a restraining order or something else, or we're going to take that child from you. Under many circumstances, under most circumstances, that's going to be unconstitutional. Now, that leaves you, as the family law practitioner, in a quandary. You know, what do you do? Under most circumstances, you're going to go out and get a restraining order against that parent, and rightly so, if you don't want the kid removed. One of the things that I want to say before I get too far into this is that at all costs, try to keep the case out of the juvenile court. Once it gets sucked into the juvenile court, it is really difficult to get out. And one of the best ways to do that is to go and talk to somebody like NaTasha. If one of your clients contacts you and says, the CPS wants to talk to me, and I need to, they say they need to come and talk to me, they're going to do it tomorrow, or they want to set up an appointment. In the period of time that it takes you to set up that appointment, if at all possible, and you think that there's a possibility those children are going to be removed, go talk to a therapist, the therapist of your choosing, somebody like NaTasha, that you hire, that is somebody that is not working for Child Protective Services, so that that person can give you an independent evaluation, and that person will be instrumental in keeping that case out of the juvenile court system. Again, you want to keep the case out of the juvenile court system if at all possible in these cases. Now, of course, if there's physical abuse, if there's some sort of psychiatric or psychological stuff going on there, you may not have any control over that. They may end up taking the child anyway. But if at all possible, you want to see if you can handle whatever you've got to handle in the juvenile court system. You're going to get a whole lot better. Well, first of all, I think, does anybody here work as a lawyer in the juvenile court system? Just one that I see in the back. So, I would be willing to bet you that the person who's working in the juvenile court system will tell you that, if they have a choice between the family court and the juvenile court, they'll pick the family court every time. At least the rules of evidence apply in the family court. So they don't in the juvenile court. So NaTasha and the therapist can help you to keep that from happening. Oops, I just turned it off. Okay, so physical examinations of children who've been removed from their parents. They may not do a physical examination of a child when they remove a child unless they have consent of the parents, there's a court order, or there's an exigent circumstance. An exigent circumstance means that the child is in immediate need of medical attention, or they're trying to preserve some sort of evidence for a case. That's a forensic medical examination. But even if there is going to be a forensic medical examination, the parents have a right to be present for that examination to comfort the child. And so therefore they have a right to notice of where that examination is going to take place and when it's going to take place. And that's also from Wallace, but it's also from a more recent case, Mann versus County of San Diego. And I'm not sure if it's up here or not, but because it's fairly recent. The Ninth Circuit ruled in Mann that those rules apply to any examination that's done at Polinsky Children's Center. And the examinations that they do there, they drew blood, they do genital and anal examinations of the children, they give inoculations, they do medical treatment, and they were doing all of that without the consent or knowledge of the parents. And one of the things the court said is the County of San Diego has been violating the rights of families in Southern California for too long. And that case went through the Ninth Circuit, and the San Diego County asked for rehearing bond that was denied, and the Supreme Court denied cert on that. So that is the law of the land. And so one of the things that you'll hear sometimes when these things come up is, well, you've got a child that's been abused by this parent. We can't let that parent go into a room. One of the things you need to remember is if they are trying to do a physical examination before a court hearing, that's just the social worker's opinion. You haven't had a judge drop a gavel and say, I find that this parent has violated this child or has harmed this child in any way. In the juvenile court, that's finding jurisdiction. Until that happens, the parent's rights are as if the social services wasn't involved. So they have a right to be present for these examinations, know where they're going to happen, and they have a right to either consent or to not consent. And if they don't consent, then before they do those examinations, there needs to be some sort of a hearing. They have to have due process, notice, and a right to be heard in front of a neutral fact finder. Van Emmerich is a case out of New York, and it's very similar to Wallace. And the woman who was the attorney in that case, Carolyn Kubitschek, is like the mother of all of these cases. And she's been doing this forever. She's argued a couple of cases in front of the U.S. Supreme Court on these cases. By the way, all of this stuff should be part of your handouts. The reason I'm going through this quickly is I got a lot of stuff to talk about here. So this is the part that talks about material evidence. So that's an exigency, or if there's a need for medical examinations. One of the reasons the court has found that this is so important is because while these kids are being examined, I mean, there's a stranger who is taking all their clothes off, asking them questions. And you know, this is a scary time for these kids. And so having a parent at least nearby, if the county decides they want to exclude the parent from the exam, they have to allow the parent to be somewhere nearby. San Diego County tried to claim that they didn't have the facilities to do that. And none of course, there have been 5 district court rulings on this in San Diego. And after the 5th one, the Mann case went up to the 9th Circuit, they finally got the message and changed the policies and practices and they actually set up a room for parents to be if they decide to exclude them. To our knowledge, no parent has ever been excluded from one of these examinations. So these are the cases in San Diego, and you can see they start in 2004. They go through 2015, the Mann case, and now the Mann case, the 9th Circuit side on that is 2018. And so from 2004 to 2018, the County of San Diego was having Groundhog Day. They kept, doing the same thing again and again and expecting a different result. And they had been told many times that they were wrong. So that's the this was made before Mann came out. So that's there is a 9th Circuit site for that. So NaTasha was talking about school interviews. We have 3 cases in which courts have said that interviewing a child at school, pulling a child out of class and interviewing them is a seizure under the 4th Amendment. And so and whether the seizure is reasonable or not is a question of fact. The county in San Diego takes the position that they can not only seize children who are suspected of being abused or neglected, but they can seize their siblings, even if there's no allegation that those siblings are being abused or neglected. And it doesn't matter where, at what point in the investigation that they do the seizure. We have a case, the Dees case, that is now in the 9th Circuit. We're kind of keeping our fingers crossed on that because oral argument is not fun. But in that case, there was an allegation made against the step siblings. 5 weeks after the investigation started, the social worker, just before she closed out her interview, went into the class and pulled these 2 little girls, one 6 and one 8, out of class and interviewed them. NaTasha, some might disagree with NaTasha on the issue of whether or not they need parental consent to do that. Our position is they do. They either need, just like before they do a physical exam, they need either parental consent, a court order, or some exigency. Now, of course, if a kid goes to school and says, "Mommy is beating me," or "Daddy is touching me inappropriately," that's a different situation. They don't want to send that kid home and put him or her in a dangerous situation. Of course they can come to school and interview under those circumstances. What we're talking about are these continuing fishing expeditions, looking for evidence, when they don't have anything to begin with. We have another case right now where crazy dad has made 22 allegations over a 2.5-year period. Every single one of them has been determined to be unfounded or inconclusive, mostly unfounded. And the 23rd comes in, and the county decides they want to interview those kids. We've told them that you have to either, and fortunately we have an ongoing case on another issue with this. The client calls us, we contact the county and say, you want to interview the child who's being, because there's siblings involved here. And the little boy, his father was the one who made the allegation, and the allegation was that he was being abused by mom. Little bumps on his head and things like that. No sexual abuse, nothing of that nature. So we allow them to come in and interview, see the little boy interview mom. They say they want to interview the older siblings. We say, sure, we need to be present for that. They say, no, never mind, we don't have to be present for that. So we say that under no circumstances can you interview the children. They go to school and interview them anyway. That's in litigation right now. We think that we are going to prevail in that case. So, but again, as a family law practitioner, you're looking at this from a different situation. I'm looking at it after the fact. I'm looking at, who can I sue for violating my client's constitutional rights? You guys have to decide that my client's kid's going to be taken if I tell the social worker no. And every single situation is going to be different. Every single interaction with the social worker is going to be different. You can try to cozy up to the social worker and say, hey, of course you can talk to our my clients and their children, but we'd like to be present for that. We have a right to be present. Now more than not, you're going to get cooperation from the social worker about that, because they know that there is something going on out there that might have them sitting across the deposition table from me. And they don't want to do that. So what will happen is that they will probably tell you okay, or they'll do the other thing. They'll go to school and interview the child. So my suggestion is when you tell them, yes, you may interview my client's children, but I need to be present. That includes any interview that you'd like to do at school. We'll be glad to cooperate, but we want, and tell your clients to tell their children, if they go to school and try to be interviewed, that they don't want to talk to the social worker. Supposedly, the county asks the children, is it okay if we talk to you? And by the way, you can end that interview anytime you want. In the Dee's case, the district court judge, Judge Benitez, asked the county council, so it was a civil trial. So how old was this little girl? Oh, she was 6. Oh, she could have gotten left anytime she wanted. Judge Benitez said, counsel, I was born on Tuesday, but it wasn't last Tuesday. No 6-year-old is going to think it's okay to get up and walk out of the principal's office. So this question of consent by children is bogus. But if they say, I don't want to talk to you unless I either have my attorney or my mom or dad present, they're supposed to stop. The other thing that they're supposed to do is they're supposed to give the child the right to have somebody from the school with them if they do agree to talk to them. We have now prosecuted almost a dozen of these cases. Not once have we ever heard that the social workers have told a child, 1, you can end the interview anytime you want. You don't have to be here if you don't want to. And 2, you can have somebody from the school be there with you. So if you're told by a social worker, yes, I want to interview a child, then again, we'd like to be present for that interview, and please make sure you contact us. We should interview our clients unless we're there, and then make sure that you tell your clients to tell their children either don't talk to them or don't or have somebody present when that happens. So, and and again, sometimes you guys are going to get in on this after the fact, and it's going to be too late to make these kinds of calls. But that's my suggestion. So. This is another Wallace quote. So this is the school interview. Is it a seizure? Yes. Are there exceptions to the warrant requirement? And we talked about the exceptions. Does the school interview qualify as a seizure? Yes, it does. These are from Rabinowitz versus County of Los Angeles and Dees versus County of Los Angeles are our cases. The Hunt case is not. It's a 10th Circuit case, but the reasoning is wonderful and it works perfectly. I love, what this is, what Judge Dolly G said in Rabinowitz. A reasonable person, let alone a reasonable 14-year-old high school sophomore, even a precocious one, confronted with the circumstances of an interview, would not feel free to leave and go about their business. Yay for Judge G. And that just basically follows in Jones and in Dees. There was a 9-year-old and a 6-year-old in the Dees case, same kind of thing. Now, Paul and I disagree a little bit on the exceptions to the interview issue, and when I say that, the only reason I say that is if there is an exigent circumstance. The exigent circumstance that we talked about, that is that, the child comes to school and complains that, they're either in danger from their mother and father, or there's some, critical piece of information like, they have bruises or marks on them. Then, in my opinion, we would be foolish to say that they can't talk to those kids. One of the things that we try never to do in our practice is create bad law. We're always on the lookout for lawyers who are out there, taking these cases who don't practice in this area and want to tilt a windmill and end up having it fall on them. So the special needs doctrine, I don't know if anybody knows what the special needs doctrine is, but that's if the kid's at school and they do a locker search because they're looking for drugs, they're looking for weapons. Under the special needs doctrine, a school official can do some sort of a seizure of a child and some sort of a inspection or the kind of thing that the Fourth Amendment would normally not allow you to do. And they can do that because they're trying to protect the safety of not only that child, but all the children around them. And that's what the special needs doctrine is. Broken down for you. So one of the things that we see is that the reasonable suspicion. They say, well, there's a reasonable suspicion, and then that's one of the exceptions to the warrant requirement. Well, the reasonable suspicion is that the person you're interviewing has committed a crime, not that they're the victim of a crime. That's where reasonable suspicion. Again, just like with just like with removal, just like with doing an examination, exigent circumstances, credible information, the child will suffer physical harm. And in addition to the Fourth Amendment rights of the children when they're seized, parents have a 14th Amendment right to make important decisions for their children. Courts have said that again and again and again in the physical exam context, in the removal and detention context. So the 14th Amendment protects the parent as well as the child. And that's where that comes into play. And this is from Judge Benitez. In the Dees case, there was actually a defense verdict in that case. And Judge Benitez granted our 54B motion and granted judgment notwithstanding the verdict. He was so upset with what the county had done in that case. And now that's on appeal. And again, we're holding our breath because oral argument is a little iffy. These are just cases that talk about, school interviews, they talk about, what a reasonable officer or reasonable social worker should have the ability to do. And again, all of this stuff should be part of your, the reason I'm speeding through this is because there's some stuff that involves what you guys are going to see when you get to the, into the juvenile court that we're going to want to talk about. Anybody guess the answer to this? Yes, they do. Yeah, both Rabinowitz and Dees have said that if you assert the right, they are supposed to allow you the right. It shouldn't be rocket science, but for some reason, I will tell you, the county we just settled a case in Sacramento, and people in Sacramento have not only changed their policies and practices with regard to physical exams of kids, but they've also agreed to change their policies and practices with regard to the interview of kids at school. And so we're kind of helping them with those policies. We don't have veto power, but we've given them examples of other counties that have allowed us to help with those, and we're going to use those as models. So that's kind of what this is all about. So the CACI. Anybody know what the CACI is? Everybody understand? The Child Abuse Central Index. So the Child Abuse Central Index is this time bomb that sits out there, and it used to be that if an allegation was substantiated or inconclusive, and NaTasha talked about those standards in the penal code section, that both of those were reported to the Attorney General and your name got put on the CACI. What's really interesting about the CACI is not only is the perpetrator's name placed on the CACI, but the victim's name is as well. And so when the victim's name is placed on there, if that person grows up to have children, and there's an allegation that somebody makes an allegation against them, they use that as one of their triggers for either substantiating or upgrading an investigation, because that person was a victim of abuse. So that person is victimized twice. It's horrible. So what you can do, so now the new penal code section, only a substantiated report, it goes on there. The way that it works is that you file, if you find that one of your clients has been placed on the CACI, I'm going to strongly suggest to you, his name's going to come up here in a minute, you call a guy by the name of Tate Lounsbury. Tate is the best guy I have ever seen that does CACI hearings. And we have, I've got some information on him. He's in, let's see, is he on? Let's see. So the way, I'm just going to speed through this real quick again and just give you an idea, because this stuff is all in your handout. You will file a grievance with the Department of Children and Family Services. What happens when you do that is they assign somebody who works for the County of San Diego to hear the grievance. So, it's kind of it used to be a serious kangaroo court until Gonzalez versus Santa Clara County came out. And that case, that mother spanked her daughter and left a very small mark. And Child Protective Services not only put her name on the CACI, but they refused to take it off during the grievance process. And the grievance officer was so obtuse about this that he refused to hear any evidence because he just wanted to use what was in the social workers' reports. And the Court of Appeals said, no, you're entitled to a fair administrative hearing, and basically told the hearing officer he really didn't know what he was doing in conducting a hearing. So that's changed a little bit. So the hearings themselves, when I say they're rarely fair here, I will say that I have seen very few that haven't been conducted by Tate Lounsbury where the clients have been taken off the CACI. It is really important that their names, if possible, be taken off the CACI. These things can affect their ability to get jobs in child care, that can affect their ability to get jobs as nurses, as law enforcement. There are a lot of people who have access to the Child Abuse Central Index, and there literally are, I think there are now like 1.5 million people whose names are on they're supposed to send you, the county used to refer to these letters when they put your name on the list, a Dear Perp letter. And, they've stopped using that terminology, but we kind of stuck it to him in trial once on that. So there's Tate. Write his number down. And if one of your clients is placed on the CACI, call him. He is an expert. We just had, he's actually handled 2 cases for us just recently. In both of those cases, he won both of the hearings. And it's because he is willing to go the next step. The next step after the grievance hearing, the Child Protective Services departments, whichever one they might be, is to file a writ in the Superior Court. And so you have a Superior Court judge who hears that writ, and if you're not satisfied with that, it goes up to the Court of Appeals. It is incredibly expensive to do that. If you guys are all charging your clients, you know just how expensive it is to spend hours and hours doing this stuff. Kate is really good at it. He's really good at winning in the hearings themselves, so you don't have to go through the whole process. And I don't really refer to too many lawyers out there, but this guy's he's special. So that takes care of a lot of what I wanted to talk about. There are a couple of other things though, and Paul would normally handle these, and I'm going to pull them up on. I'm going to get there. I don't think they're. I think that they're really part of your handouts. So I don't think they're on there. So let's see. So some of the things that you're going to want to do when you do have a case that is involved in Child Protective Services, social workers have opened a case, you're going to want to get their file. So anybody familiar with the 827 process in the Welfare Institution here? So of course, you're not just allowed to, so hand up number 1. So you're not just allowed to obviously have these documents. You have to ask the Superior Court for permission to get these documents. We have a hard time getting them when we're filing lawsuits against the county. So I'm just assuming it's just as hard for you guys, although we may have somebody who could talk to that tonight. So you file, what you're filing is an 827, and that's starts with handout number 1. And it gives you the list of the things that you're looking for. When you're looking for the juvenile court file, you're not just looking for, it's a term of art, the juvenile court file. So the case file. The juvenile court case file encompasses everything that's in the juvenile court and everything that is in the social workers' documents as well. There's been a little discussion tonight, I think, about a delivered service log. A delivered service log is the document that social workers fill out online to keep track of what they're doing in their cases. And they're supposed to list everything that is of importance with any client, and they refer to the people they work with, including the parents, including the kids, as their clients. And any outside person who might have relevant information, therapists, doctors, teachers, all that good stuff. You're going to want all of that. So you're going to want to try, and one of the things that you should do is send out a letter to CPS as soon as you get the case, if you know that there is a case, open with CPS, and ask them to maintain their entire file, including any emails. The county's practice is to destroy emails after 30 days. So ask them to keep all of their emails. We send out these letters on our civil rights cases immediately upon taking a case, because we don't want them getting rid of any emails that they have. So going back to the handout 1, the JB 570, the request for disclosure of juvenile court file, notice of the 71, notice of request for disclosure of juvenile court file. There's an objection to release a juvenile court file. You have to serve at the same time. You have to not only serve the court with this, you have to serve all of the attorneys in the juvie court. You have to serve any other parent who's involved in the juvie court. And again, if you guys have your handouts, it's probably better to look at that than it's not up there right now. So, so you need to make sure that everybody gets a copy of this or it'll get kicked back. You sent a proposed order, 573, the order after review, and the disclosure of juvenile court records protective order. You have a protective order that goes with this. But it's important that you get these documents because even if your client has a copy of their own file, odds are you're not going to be able to use this in court. You won't be able to use it for two reasons. First of all, it's hearsay, of course. Second reason is it's considered confidential even though your client has it. And they're not supposed to disclose it outside of the juvenile court proceeding except to their lawyers. It means you can't disclose it to anybody else. So you want to make sure that you get the juvenile court's permission to do this. Depending on where you are, in San Diego County, it takes maybe 2 months to get these documents. So you need to get them early. In Los Angeles, it takes 18 months to get these documents.
Donnie, when you have the manual allows the officer conducting the grievance hearing to be an employee, what is the manual?
Okay, so the manual is, the manual is, and this is the CACI hearing again. The manual is the manual the County of San Diego uses, and it's statewide. It's a statewide manual actually, that allows for who can be a hearing officer. And so that manual is used by every county in the state when they're setting up their grievance procedures. And by the way, it's not just a grievance procedure in the county on the CACI. Police officers can also place someone on the CACI. So that means that somebody from SDPD will be able to place somebody on the CACI. You want them off the CACI, you got to ask them to remove them. And only they can do it. And even if the determination is made in the juvenile court that the allegations are, we have one, the Mann case, where the allegations, the juvenile court found that the allegations were not true. They still refused to remove Mr. Mann from the CACI because the social worker still thought that he'd done something. He spanked his child, by the way. Left a tiny little mark. So we had to go through that process. One of the things that happened is that we were able to get his name removed as a result of the settlement of the underlying case. So and they agreed to do that. But the easiest way to do that now is to do the grievance hearing. But that's what that means.
Okay, thank you.
So, once you get the documents, you're going to have to sign a protective order saying that you'll be killed if you disclose these records to anybody other than the people you're allowed to disclose them to. You have to destroy them at the end of the case. That's standard procedure in every case. You'll have county counsel up there, complaining that you're getting the records, but you are entitled to those records. In the meantime, though, your client is entitled to get a copy of their file themselves. So if you want to see what's in there before you can get this stuff used in court, send your client down because only they can do it. You can't as the lawyer, but they can. Because you're not the juvenile court lawyer. You can have them go down and they're allowed to view and make copies of their file under 127. So send them down and say, go tell them you want a copy of the file. And that's how you did that. So, let's see. Handout number 2. So handout number 2 is how you get documents that law enforcement might have. And that's under 828 of the juvenile court, or the Law Institution Code. Pretty much the same process as getting a juvenile court file, but you're kind of getting the cops files. Believe it or not, it's a lot easier to get documents from the police than it is the juvenile court system. So, and let me just say this too. I come from the far left side of the political spectrum. I'm a liberal with a big L and a little L. I'm very proud of it. And I know that there are kids out there who shouldn't be with their parents, and there are some fabulous social workers out there too. Those aren't the people I deal with. I deal with the people who work in a system that is closed to the public, that gives them an incredible amount of power, and puts them in a juvenile court, in a court system that almost always defers to them. And so they really have almost unchecked power once that case is sucked into the juvenile court. That's why you want to keep it out of there, as it all wants. All right, let's trend it. There are lots of documents I want to talk about. Just give you a brief overview of them. So number 3 is that wonderful delivered service log that I told you about, and that's handout number 3. What we found in the delivered service logs is that while the portions of this file that say completion date, all that good stuff, that can't change. But the narrative within there, a social worker can go back into that narrative at any time and change the narrative. We've actually found, we've had cases where we pulled cases, we got the delivered service log from the juvenile court attorney, and then we did the 827, got the new delivered service log on the same day, the same entry, and it was different. And the only way you can tell that, and why they did it and when they did it, is that there's a thing you can get from the state of California that tells you when they've gone into the system. But you have to get that from the state. It's an incredible thing. I mean, it is truly incredible. So the only way you would know is that they happened to print that out and gave it to somebody before that they changed it. So beware of that. We're coming up on the critical stuff that I really want to talk about here. And I'm going to skip number 4 because that's the narrative, and I think we've talked about that in the emergency response referral. I think NaTasha covered that. Go to number 6. Letter to the family court. Letter to the family court. Number 6 and number 7 are absolutely critical to family law workers. These are documents that you might not even know are in your family court file because they're in a little vanilla envelope in the file confidential. These are documents that the social worker will send to the family court, and they'll tell the family court, basically, this is how we see this case. We think this case is, this person or that. We've determined that the allegations against mom are founded, they're substantiated. In the D's case, the social worker actually, my client had no idea that this was in her family law file until we did the juvenile court. We got the 827 and saw that it had been sent. And what the social worker had sent to the juvenile court was that the allegations against mom were substantiated. The allegations against mom were unfounded. She lied. And she sent it to the juvenile court, or the family court anyway. So that's something that you won't know unless you ask for it. So you'll need to ask the juvenile court for that letter and the next one. Let's see, letter to the family court, and the next one is non-custodial parent letter. That's the letter that will tell the juvenile court or the family court what the social worker thinks about the non-custodial parent, and that's usually when they're trying to get the non-custodial parent to get custody of the kid. So my time is almost up here. They're madly waiting. My 5-minute sign hit me a few minutes ago. I know that I've brushed through a lot of stuff very quickly. I am more than happy to answer questions later if you have questions, or you can call me if you have questions, and I'll be glad to talk to you about it. This is a very complicated, issue, but if at all possible, keep your clients out of the juvenile court.
Thank you, Donnie. We're going to throw this back to NaTasha now. Before I do that, I just want to make sure everyone knows we'll be sending out PowerPoints for all the information you've been shown tonight on a follow-up email after tonight. So you're going to have that accessible. I would expect sometime tomorrow, so don't panic. We're going to get the material. Now, NaTasha is going to now speak about the therapist's role. once child welfare services becomes involved. What's the unification process, treatment plans, and how to prepare your clients.
So all that information just brought up a lot of cases that like triggered up here, like, oh, I'm glad I don't work there anymore. I left 2010. That's when all the lawsuits started flying in. And I got out right in time because I have friends that are still there, and yeah, the county is being sued a lot. And the CACI, you brought up the CACI, that is a very big one. I remember having cases and parents calling me years later asking me why I'm on the CACI, I can't get a job. I think one mom was a retired Air Force pilot. She was trying to get a job. She couldn't. She was on the CACI and she was not the victim or the perpetrator. So I'm glad to hear the developments in that. I removed myself from there and never wanted to, but it's definitely good work that you're doing, so I definitely appreciate that.
Well, that's Kate that's doing that work.
Yeah, that will informing them, but yeah, and like you said, there are good social workers in the system, and there are bad ones, just like in any job. So what I want to bring it back to for our therapists in the room is talking about the term provider at this point and how they work with the families. Now, clients who have a therapist prior to having court-ordered services or case plan or even voluntary does not have to have a term provider. If they've already established a rapport with the therapist or secured one when they're being investigated and they know maybe it's a mental health issue that the social worker is looking at, I highly recommend that clients or your clients secure their own therapist prior, even if it's voluntary, because you never know, these cases can take a turn really quick, and then they have, a case plan, and then 9 times out of 10, if they don't have a therapist already, then they're going to have to use a term provider. Not all some term providers also see other clients that are not court involved, but most of the time, if you have a client that is CPS involved or becomes CPS involved when you're working with these clients, you really need to inform them, and I'm sure most of you guys, either the agencies you work for or your private practice policies, will let them know like how far you're willing and what you will provide if you're going to appear in court. As therapists, at least for me, I always want to stay out of court. I don't want to be summoned. I lay that clear in my private practice disclosure statements, but at times I've had many clients that were not coming for depression or anxiety for themselves, and then ended up with a child welfare case. And just by chance, because I did work in the field, I was able to just advise them on, if they continue to see me, or if they have to be mandated to see a social worker, a therapist, they can choose to continue to see me and what I will and will not provide to the court, because the term therapists are trained to provide information to the court a little bit different, I think, than therapists in private practice would, and what they have to disclose. So Optum is the agency that contracts term therapists, and not only just therapists, mental health therapists, but they also do psychological exams, adoption evaluation, autism evaluation, psychosexual, psychiatry, children and adolescents, sexual behavior problem evaluations. So that all that runs a gamut on what is term provider. So one of the main things here for clinical risk documentation that term providers have to document, and most times in private practice, we document risk issues. We are mandated reporters. So in general, we assess for all these things: suicide, homicide ideations, a thorough risk assessment. Term therapists may provide more of a thorough risk assessment to the court of what the social worker is looking for. Is the parents taking responsibility? Are they being a protective parent? They want summaries, and they usually want quarterly summaries. The court, when the case goes to reunification, if there's court involved, every court hearing, usually the protective service worker will ask the term therapist, I need a quarterly report. How is the parent and or the minor progressing in therapy? And you really have to lay that out for the board. Now, term therapists will have this documentation, and you can find this on the Optum, this public record. This is what their initial treatment plan will look like, and if you see first update, second update, third update, each time they go to court, the social worker is requesting an update on how the parent and or the minor is progressing in therapy, and really documenting the risk of harm is primary at this point, and also, again, is the parent accepting accountability, and are they being a protective parent? As a protective service worker, when I was in that role, the reason why I'm a therapist today is because I was a protective service worker, and I really enjoyed getting the therapist treatment plan, because I went into child protective services like, why wouldn't a woman just leave? Why would they stay? Like, I really couldn't understand, like, why, if you're, getting beat up by your boyfriend or your husband, you would choose them over your child. I just couldn't wrap my head around it. And then as I consulted with therapists and read treatment plans and how to stay up till midnight running court reports, I realized the trauma that came from it. And then I'm like, oh. And then when I saw families, women that have been so broken actually get their child back, and they were protective or they got off of drugs, and I could close the case and return the kid with the bulb. I was like, okay, I'm going to be on the other side. What did that therapist do to help this mom, process her trauma, become a better parent, and bring families back together? And reading all these treatment plans from term therapists and consulting, I went back to school when I was a PSW. So not only was I, doing this work, I was also in training to become a therapist. And then as soon as I graduated, I moved out of that system. But I do have to thank Child Welfare Services for me becoming a therapist today, because I was able to see more objectively and really understand how trauma, a lot of times, parents are not able to be protected. So this is basically what an initial treatment plan would look like from a term therapist. You can tailor yours if you're working with clients that are involved with CWS and may want to have your reports for them so they don't have to go to a mandated report. To that, just knowing that they need these quarterly updates to really document if parents are taking accountability. So this is just an example I put on here just to elaborate a little bit more about treatment goals. This is if they are suffering from depression or anxiety. Most of the time, in talking to some of my good friends that are currently protective service workers, the county is broke because they're being sued over $8 million. So they really try not to add in the case plan mandated therapy because it's expensive. They have to pay for it. So from what I understand from my friends who currently, they said that is like the last thing. We try to send them to support groups, parenting classes. But if there's psychosis, if there are really severe mental health issues, then they will mandate them to have a therapist, most likely. And so these are kind of some of from the term treatment plan Optum that you will find some of the goals that they will have for the client. And for clients who are not on medication, and evaluations may be beneficial. So if stabilizing the client on medications, you will have to write that in the treatment goal. So this is just for your reference. So clinical risk documentation and safety guidelines. I think you're going to talk about safety plans a little bit too. But these all can be implemented. It doesn't have to be court involved. And these all could be implemented as well as a private practice therapist. If you, being a mandated reporter, need to make a mandate report, or if your client does disclose, my husband is hitting me, or they are in harm's way, you can always create clearly your own safety plan, even if they're not court involved or court involved. And there's some really good ways to do that using these tools that the term therapists use as well. These are one of the safety plan guidelines that you can reference for clients. There's a domestic violence safety plan, which will probably be used a lot after Super Bowl. And child protective safety plan, these are all forms on Optum that you can, that are readily available. So really just looking at the red flags. The therapist helps, the client fills this out, the therapist kind of just prompts them to complete the safety plan. And that is the end of my part.
Right. So who's throwing Super Bowl parties this weekend?
Yeah.
Gonna have your safety plan documents?
At the door for everybody.
Excellent. All right, well, I was accurate when I said that we had too much information for the time allotted. I was out of my mind when I said we would have 2 sessions for question and answers. So we're gonna have enough time. Now we're gonna move on to the last presenter this evening. That's Leah Boucek. She is the family law facilitator for the County of San Diego. She's held that position since July of 2018 after serving as a staff attorney since 2014. In her role as the facilitator, Ms. Boucek manages the 4 San Diego offices that provide assistance to self-represented litigants in general family law cases and Title IV-D cases. Prior to joining the court, she had private practice for 16 years, spent 3 years working in planned giving for a nonprofit organization. She is a graduate of California Western School of Law, holds a BA degree in business administration from Point Loma Nazarene University. She's going to give you some information now from FCS, Family Court Services perspective, and her perspective as family law facilitator.
So whoever picked me to go last knows how fast I talk, so I'm going to try to get you out on time. And I did not have a coffee, which means you might actually understand me. So you're welcome. So I think there's some mystery and confusion sometimes about the CWS involvement in family court, and that there's maybe some sort of direct pipeline of information, and we have chatty calls with social workers and whatnot. None of that is true. There might have been a time, a very long time ago, that a judicial officer or someone from the court could get a hold of a social worker to discuss a case. That has not been true for a very long time. This is most definitely not true currently. So for child welfare services involvement, as NaTasha explained, a referral can go to the hotline at any time for any reason, and then they're assessing whether or not it's going to be assigned to a social worker. So if it is, then the social worker is, CWS is determining in what timeline the social worker needs to address the issues, obviously depending on the circumstances. And so then they'll do their interviews, determine the next steps. So how do people get to family court after contact with CWS? Well, they may not, right? I mean, they may close the case. It may not be an issue for the family. Somebody may never bring it up, and so family court might not know that CWS was involved. The party, your clients, and we get this a lot with the self-represented litigants, of course, throw around the CWS involvement a lot. I have CWS involvement in my case, or the social worker said this, or whatever. Again, it may be that they've had a number of contacts with CWS. That does not necessarily mean that there's going to be anything submitted in writing. If the party mentions to the social worker that they have a case in family court or intend to go to family court to file something, then the social worker can provide them with a letter to family court. So I didn't want to interrupt Donnie during his presentation because it's rude. But the family court letter procedure has changed. So the 2 letters that are in your handouts, they no longer exist. There is a single letter, and if it goes to family court, you're going to know about it because your client has it. Okay, so that doesn't come directly to us. It goes to the parties. So that is to basically say that, and I'll try to provide a sample when Mark sends out the materials. So I think I can access that. So that's basically the date of the referral, what the allegations are. It's literally just, and it says right on it, verification of a CWS referral. So there's an open case, so something's pending. So they bring that to you, or usually for us with the SRLs, they bring it to us. So I'm going to get my emergency court order, right? Is it an emergency? Well, it depends on who you ask. So what are the allegations? What would they be putting in their declaration? A letter to family court in and of itself, people think, because I have something in hand from a social worker, then I'm good to go. Well, you may come in and have emergency circumstances for an emergency custody order and have nothing from CWS, or you might have something from CWS and still not have an emergency, or your judicial officer may not think it's an emergency. One of our customers today, his emergency is that his children are riding the bus to school. So he would like to go ex parte because he doesn't think that's safe. As a parent, does he absolutely have that right? Yes. Can he make that request? Yes. Is he going to get an emergency custody order? I don't think so, but I don't get to decide that. So the other thing is, it's super helpful from the parties or your clients is that they have the letter and they don't let you know. So you find out about it like after the fact. They've already been to family court services, whatever it may be. So if the situation's more serious and the parties get a safety plan, then obviously if they bring that to court, then that's a much more serious situation that I believe will grant them certainly an ex parte appearance. Whether they get an emergency custody order again is up to their individual department. So the safety plan, depending on whether the parties are living together, whether they're separated, what the allegations are, they may have a joint safety plan that they're working on together. They might have individual safety plans. So one of our recent cases was a father who comes in to change the custody order because the allegation is some sort of sexual abuse with mom's current boyfriend who's living in the home with mom and the children. So dad's safety plan includes coming to family court to try to get an order modified. Mom's safety plan, I hope, includes that the boyfriend or whoever is can't be there when the children are there. And then the social worker is tracking what each of them is doing and hopefully doing to keep the children safe. Just a side note, because this has come up with our office as far as submitting things to court. Some judicial officers consider the letters to family court and the safety plans confidential, like confidential CWS records. A party walks in with it, it's not, I didn't have to request it from CWS. It wasn't a confidential record that needed to be disclosed to us. So if they come in and request to file it as a basis for their ex parte, then they're permitted to do that. But I think some departments are requiring the parties to sign a stipulation and cite the Welfare Institutions Code before they'll include anything in the file, and then they have it go in as confidential. I spoke to CWS about that, and they said that the letters and the safety plans are provided to the parties specifically to assist them if they need to come to family court, so that we have that information. Also, just not a side note, but remember, a social worker directing somebody to family court to get a restraining order, get a custody order, is like a police officer directing somebody to family court to get a restraining order. So it's, people will say all the time, well, why did I get sent here to do this? Well, where else are they going to send you? And depending on what you are communicating your problem to be, they may or may not know the appropriate order to request. So of course, part of what we assess and what you're going to assess is, if somebody comes in and they say, I want a restraining order, and you go through the fact, and there's no domestic violence whatsoever, doesn't mean you're automatically going to request a restraining order because it's written on the safety plan. You might, or you might ask for a custody order and a restraining order. I think that the intention is the social worker sees that the parties are following through, that they didn't give them a safety plan and then they did not go to court and ask for anything. So basically, are they taking steps to protect the children, or did they ask for what the social worker told them to ask for, and then they were denied at court? They, of course, should be asking for something in the alternative. If it's a restraining order and you don't think there's a basis for a domestic violence restraining order, that they're also addressing the issue of custody and visitation. So when the parties get to family court services, so here's the other thing. Family court services does not have an automatic background check, automatic CWS records check. So if the parties do not bring it up in family court services, it's not going to be part of the report. So hopefully, if it's enough of an issue, then they are going to bring up, they're in communication with the social worker, and or there's been CWS allegations, even if the social worker didn't follow through with anything, because then if they bring it up in family court services, just like if they bring up an arrest for something, then they're going to do the appropriate check. At that point, if CWS involvement is raised, then FCS is going to telephone the CWS records department to see if there's an open CWS case, and they're going to verbally obtain the information that would be in the letter to family court, which is date the child abuse referral was received, the allegation, the identified victims, the alleged perpetrator, and if there is an assigned social worker. That is simply so that they know that a case is open. That's because that may change the timing on them being able to submit a report. So maybe that the hearing needs to be continued until they know the answer to that. So again, they are not having any conversations with the social worker. This is true of the courtroom as well. So there's not, the courtroom may be able to request records if a case is closed, but in writing, and they're not picking up the phone and verifying that something is an emergency or not an emergency. If the CWS case is closed, then the FCS counselor is going to telephone CWS records again, but this is going to be to obtain the same information along with the closing date and then the conclusion, at which point then the FCS counselor is going to fax or email a request to CWS Legal Services to obtain narratives, dispo report, status review report, closing case summary, safety plan, whatever records they can to, again, not automatically submit those to the judicial officer or to the court, to include that information as is relevant in the recommendation that they make. And so it still would be that the party, the attorney, the judicial officer can do it if they want, which is to request the actual records so that the court has it for the hearing or the trial. So it's going to take maybe 2 to 4 weeks before the records are received by FCS. So the only possibly expedited thing is that FCS might get records faster than somebody else. But again, they're not like faxing them over immediately or sending something different. They still have to go through the same process. That's when you'll see the request to continue the hearing. So any necessary information can be included in the report. The only other possible forms of communication between FCS and CWS is going to be if FCS is reporting abuse allegations to the hotline, and then they have to follow that up with a written report. Or the only other possible letter to family court is that CWS is providing a letter to family court and FCS when they change the conclusion of an investigation on a referral. That letter is filed and copied, routed to the current FCS counselor if there's an active case, or put in the FCS file if no current counselor is assigned. So again, letters to family court, the initial letter, not confidential, provided directly to the party, and then brought to court if the party brings it. This other one would be sent automatically to notify the court, and then that would be placed in a confidential file. The reason, I think there were a number of reasons for the change in the letter procedure, one of which is the original letter that was sent to family court, they might not even have a case. We're holding on to letters and it goes to the business office. Sometimes it would come to FLF. Sometimes it would go to FCS. And so anyway, it's, like I said, it's meant basically just to verify the case. Then once it's closed, then whoever is appropriate can make the request for the records.
Could I ask you a quick question? So what from DCFS or HHSA in San Diego, what goes into the confidential file from them?
From them right now, it would be just that letter changing the conclusion, or if they submit records, if they go to FCS, they're in an FCS file and not the court file.
And so does the family law attorney have access to those documents if he asks the court for those documents and
No.
review them?
No, I work at the court and I have access to confidential records, and I would not be able to access those. So like, if FCS is keeping them in an FCS file, that's not the same as being in the court file.
So how do you confirm that what's in those records that come from DCFS or HHSA is accurate?
Well, like I said, I don't have access to them, and I'm working.
That's the problem. The problem that I see, and it's one of the problems that I think that these guys really are going to have, is that because DCFS or HHSA, and DCFS is Los Angeles, HHSA is San Diego, because they say something is true, doesn't make it true. And so if the judge is getting that information, and that is not accurate information, that's something that can be prejudicial with the client down the road. And so there should be some way for the attorney to at least be able to view that and be able to talk to their clients about that to make sure that what's in there is accurate. As I said, in the D's case, the allegation was unfounded. The social worker sent, that was that final letter saying that change in status, saying that the allegation is substantiated. That time bomb sits in the family court file, and they've refused to remove it. So
That letter would be acceptable.
well, it was in the confidential file. So that my clients had no idea that it was in.
Okay, so maybe I lied when I said there'd be a question at the end. We have a couple of minutes for questions. Before I do that, I just wanted to say, after listening tonight, I think an important practice tip for the family law attorney is if you have child welfare services involved, one, it might be good to keep Tate's information that we put on the screen, and two, partner up with a therapist now. Someone who can start maybe advising you, if not your client, on what you can do to prevent your case from slipping into the juvenile court. Now, with that being said, who's got the most important question tonight? Yes, on the back row.
So how do you get a judge to see a CWS? If you want the judge to see the reports and how many reports are filed, how do you get him to see this?
Well, I think you heard from Donnie in regards to the 827 petition. You want to get that in?
It hasn't been sent to juvenile court. It's just allegations in CWS that we want to lodge with the court.
An allegation.
There'll still be a case filed.
Is there still a juvenile case?
You're talking about a referral, right?
Yeah.
Okay, if there's been a referral, there's going to be a case opened. That means there's going to be information available. You can use your 827 petition to get that information. What you want to be careful about, though, before you start providing information to the court, that information is confidential. As Donnie was saying, if you use it, you better be sure of how you're using it, because you can get into trouble. It's actually, I think, a misdemeanor
It is.
for you to file that information in a public document. So you need to be very careful and check your letters, your protective orders that are coming with the material. It will tell you if you can use the material in court, but don't make it a public record. Don't attach it to a declaration, and be careful how you approach using that.
Could I make one other comment too? One of the things that NaTasha brought up, and I think we both talked a little bit about this. If you have two parents in the house and one parent is considered the offending parent, and CPS wants to go talk to them, have them move out. Have the offending parent leave immediately, so that there's no imminent danger of serious bodily injury that would require the removal of that child to prevent, CPS from getting involved in the case, until you can get NaTasha involved, until you can get, you get things lined up for your client. So have them go stay at a hotel, have them go, whatever, just make sure that they're out of the house. And we consider those safety plans, we think that they're coercive, and that they're not sometimes used for the purposes that they're intended.
They can show that they're being a protective parent.
Sure.
A lot of times social workers love that. Oh, the husband's going to move out, or I'm going to leave to grandma. We have this safety plan. Social workers have a lot of cases, so when the client does that, it just makes their job a lot easier and keeps it out of the court.
So be proactive, and thank you for coming tonight.